2 in the matter of Tindall and another, Chief Constable, Thames Valley Police and another.
Mr. Burr.
May it please you, my ladies, my lords. A couple of just points before I get to my route map. Could I thank you for your leniency yesterday?
You're
which
welcome.
is greatly appreciated.
You look a lot better today.
I feel a
I
bit
would
better.
say so, yes.
Yeah, I've dosed myself up. Also, we made a fundamental error on the representation sheet by disgracefully not putting in Mr. Fairgrieve, who is on the pleading.
Yes,
He's a part of the
we did
legal
notice
team,
that, yes.
it is certainly, in fact, is watching the live stream and taking active part in the live stream from Paris. So there's an international flavour to this case. I've got 8 separate sections, and I hope to be able to finish in the morning. There might be a very slight run over, but hopefully I'll be okay. I'm going to cover first of all the general principles from the 3 apex cases. I'm then going to go to correcting what we say with the greatest of respect is some misunderstandings as a result particularly of interchanges between my Lord Justice Stuart-Smith and Mr. Warnock in relation to what Robinson particularly establishes. Then we'll go the 3rd section, the test in making matters worse, that's ground 1. Then we'll go to the alternative route. This is really all part and parcel actually of ground 1, so 3 and 4 read together. Yep. The alternative route to liability under Tafaris 2, that's the additional preventing somebody else from protecting the claimant. The 4th/5th section is control, ground 2, Tafaris exception number 3. We'll then address the hypotheticals that were discussed yesterday. I've then got a few words and a bit of authority on ground 3, the need for a trial, why this case should not be done on hypothetical fact, and then a few words in conclusion.
Well, it's not being done on hypothetical facts. It's being done on the facts that you've chosen to plead.
Just, can you forgive me a minute, my Lord?
Don't worry.
This technology is not quite working. Sorry, could you repeat that? I don't know whether the loop is turned on.
It's not hypothetical facts. It's facts that you've chosen to plead.
No, of course.
And you should have chosen all those material facts, all those facts that are material and necessary to your cause of action.
Of course we should, and we did. Well, rather than get into that now, could I? I'm happy to address that now. And in fact, if you want me to, on that, it might just be more efficient.
No, I don't want to take you out of your order. It's just at some stage. Speaking entirely for myself, I have a view as to what the proper use of witness statements and so on and so forth is, but I think and you've confirmed, and this is all I was keen to establish, that if there are material facts giving rise to a cause of action, you should have pleaded them.
Well, I hear what your Lordship says, but that view needs to be looked at very clearly in the light of what the House of Lords have said in Vendanta, what Lord Justice Coulson has said in the Begum case, the approach in Arundel of Mrs. Justice Lang, and of course the Master, following all of that. Now I totally accept the point about we're taking it at its highest, so we can't do any better. But there are, as there are examples that the learned friend relies upon about issues of high principle being dealt with on strikeouts, there are equally now, and there seems to be an emerging thought, particularly in this area, where the slate is clean in terms of what the higher courts particularly, so the Court of, well, with the exception of the child protection cases that I mentioned in when I just interjected very quickly yesterday, where there has been some exploration of what Tafaris 1 requires in the context of failure to remove children who are at risk, so social service negligence cases. That has been looked at. It has yet to get to the Court of Appeal, but it's almost there. In terms of control, status, and, well, making matters worse, but of course it's not an exception, and Tafaris 2, the protection point, there's nothing. So what Lord Justice Coulson says, paragraph, I think, 61 of Begum. In fact, can I just, so I'd like to just deal this point once more. It's tab 17, the bundle. And if you look at, let's go to the end of my note, paragraph, we've got a paragraph 22-23, I won't take you through it, but if you just mark that, you'll see that's just a nice reminder of what certainly this constitution thought was the correct test on both summary judgment and strikeouts. And we got all the classic material there about realistic claim carries some degree of conviction. You don't look too deeply into what's behind the pleading. You've got to show that the factual allegations are demonstrably unsupportable. But crucially, you only strike out a case if it's bound to fail. Now, if that's really, I mean, just a quick synopsis of 22 and 23. But then if you look at 37, the second consequence is that the making of so many critical assumptions. We say there are both assumptions, our own assumptions, of course, in terms of our pleaded facts, but also unanswered questions, which at some stage I will get to. So this crucial point about what would have happened if they had not attended at all, which is a foundational concept that comes from East Sussex, and then we see through Stoughton and Wise, Gorringe, Camberland counties, and so on. What would have happened had they, would they have sat in their hands? What would have happened? And I'll go through those questions, not now, but I will get there. Now, just going back to 37, so he refers to critical assumptions. In a case where the duty alleged could fairly be described as an unusual extension of an existing principle, and I'm not saying this is novel. I mean, there are maybe novel elements, looking at what facts are necessary to satisfy whatever the legal test is, may take us into the doubtful area of deciding important questions of law on assumed facts, i.e. hypothetical facts, because there has been no trial, as identified by Lord Brown-Wilkinson in Barrett and Lord Briggs in Vendanta. Just in Barrett, you may very well know this. In Barrett in the House of Lords, there was an assumption that the Educational Psychology Service was open to all, a bit like a hospital. So he made findings of fact on that, and there's a lot of analysis. Turned out that that was absolutely wrong. Now, plainly a different example, but an example of exactly the same type of problem that can crop up. But then perhaps most significantly of all, I got it marked up at 70, I think it's 71 rather than 61. There is one final point which favours the dismissal of the appeal on ground one. That was to try to get rid of the claim. So this is an appellant. This is the case all about the dismantling of, I think, rusty old ships in Bangladesh, and an argument about whether the company at the top of the chain was responsible and levels of control over subsidiaries. So a sort of toxic damage case. As I have endeavoured to show, claims based on a duty of care in circumstances where the damage has been caused by a third party are currently at the forefront of the development of the law of negligence. The alleged duty in this case could certainly be regarded as being on the edge of that development. But in such circumstances, I agree with the judge that following the principle in Barrett and Vendanta, we'll look at Vendanta in a moment, it would be inappropriate to strike out the claim based on the alleged duty of care on assumptions in the absence of any finding of fact. So that's, and then Vendanta is at core 48. No, sorry, that's the skeleton. Vendanta is at... There you go. Yeah, tab 15, I'm grateful. And it is paragraph 48. Well, paragraph 46 to 48. The main thrust of the defendant's case under this is Authorities Bundle 534. Tell me if I'm going too quickly. The main thrust of the defendant's case under this heading was that a conclusion that Vendanta had incurred a duty of care to the claimants would involve a novel and controversial extension of the boundaries of the tort of negligence beyond any established category. Just stopping there. We know the categories, certainly of exceptions, because of the embracing by really well, two fully embracing Stelios Tafaris and Sandy Steele's analysis in those, which comes from those two articles in Robinson and Poole. So what we're talking about, we know they're established, but we're talking about their width, how narrow the courts, both this court and probably at some stage, and I'm not saying here necessarily the Supreme Court, will have to look again at precisely what those tests are. Because these are really difficult and essential issues in striking the balance between protecting the state, the general principle that flows from East Suffolk, and providing some form of justice, and I know you're not a jury, in relation to how these exceptions are going to work. And that is at the core of the case, of the arguments in the child protection area, where the law has gone from the recognition of Bolam-style East Berkshire, I'm sure you're familiar with all of those cases, about social workers being professionals who have an assumption of responsibility, a sort of paragraph that, your lordship raised your eyes slightly when you were taken to paragraph 38 of Gorringe, where Lord Hoffman talks about that category of cases, Phelps, Barrett, the whole load of them, which are said to maybe be a bit too expansionist, but have been explained in this retrenching area as cases which are clearly within the general Robinson scheme because of special relationships. Now, that exists, everybody on the claimant side and the child protection against the insurers and the defendant say has to be accommodated within this scheme because it eviscerates decades of authority. And there are dissents from Lady Hale in relation to that, powerful dissents from Lady Hale and Lord Kerr on exactly that issue. You start from Michael and work onwards. That issue is playing out now, and it's an exception. It's not so much, you asked me earlier on, or yesterday, am I arguing assumption of responsibility? It's on the pleadings, but it's extremely light touch because it's not a classic assumption of responsibility case. But there's a merger of concepts, as we'll see when we look at A.J. Allen and the Scottish cases. So here we've got a big question about how you populate those exceptions. And when you're doing that, you do it, to get back to where I was, I'm not sure if I'm going to take you to Vendanta in a minute, you look at, you have to do it after a trial if there is anything as controversial as this. And that certainly, that's a very strong submission in my respectful submission, a very strong point in my respectful submission in relation certainly to where we go on, let's call it our alternative case, relating to if you're against us on, I'm not giving up at all on making matters worse. But in relation to control and Tafaris 2, 906B of OLL, your lordship's very persuasive point about the misdirection of the helicopter falls within Tafaris 2. So we don't even need making things worse. So all of that is really, really important areas of the law, to strike it out on the basis that it's doomed to fail and on hypothetical fact, I say, with the greatest respect to Mr. Warnock and your lordships, you would be making a very, very major error. But now, getting back to Lord Briggs. So, thrust of the defendant's case under this heading was that a conclusion that Vendanta incurred a duty of care to the claimants would involve a novel and controversial...
Which paragraph?
Oh, sorry, forgive me, 46.
Thank you.
534. The main thrust of the defendant's case under this heading was that a conclusion that Vendanta had incurred a duty of care to the claimants would involve a novel and controversial extension of the boundaries of the tort of negligence beyond any established category, calling for a cautious incremental approach by analogy with established categories, which therefore required a detailed investigation of the claimant's case, which neither the judge nor the Court of Appeal carried out. And then 47 we can skip. The heart of it is at 48. It might be thought that an assertion that the claim against Vendanta raised a novel and controversial issue in the common law of negligence made it inherently unsuitable for summary determination. It is well settled that difficult issues of law of that kind are best resolved once all the facts have been ascertained at trial, rather than upon the necessarily abbreviated and hypothetical basis of pleadings and assumed facts. So,
but this is working out Chandler and Cape. This is working out the consequences of the decision of this court in Chandler and Cape, which is undoubtedly a state of the law that is in flux.
yeah.
We're confronted by Court of Appeal and Supreme Court authority, which, until you show us the point of distinction,
yeah.
is binding on us.
Oh, I'm not in any way... Well, are you talking about Robinson and Poole there? Or,
Well, I'm talking about East Suffolk, Capital and Counties,
well,
Robinson, Gorringe,
yeah.
Stovin.
Well, there is no precedential, if that's the correct word, blockage in the way of our argument, we say. You might at the moment think so because of what Mr. Warnock, an undoubtedly extremely skilled advocate, has contributed to the second ground of my submissions, which is correcting some misunderstandings. Once I clear those misunderstandings away, if I am able to do that, and if you're with me, then it may well be that your lordships and I don't know, your ladyship's view might change. But I think that's probably all I need to say on ground 3. So could I just give you, I won't take time taking you through it because it's in many ways more of the same, but before you do give judgment, I'd be very grateful if you could have a look at the Arundel case. I'll just give you the reference. Paragraphs 84 to 94. That's at 565 to 566 of the bundle at tab 16.
But what are you asking us to derive from them, Mr. What are you asking us to derive from them?
Well, what I'm asking you to derive from all of that is the very point I have made, that that making matters worse and the arguments on exceptions are really going to be very fact sensitive, and that it's really what the master herself said in abbreviated terms in the core bundle. And again, I'll just identify the passages for you. The judgment is at paragraph 5. And you see it's paragraph 3. The losing party in this case is the first defendant. I've taken the view that with the law as to the imposition of the duty of care being in a state of flux, which it is, and of course we've got to make that point good, and with any duty of care being a fact-dependent decision, if there are issues as to whether the case concerns the issue of making matters worse or not making things better, as illustrated by the Arundel case, to strike this out without a trial would be incorrect. It's a matter of a trial on the evidence. I've considered the various authorities, and simply put, it is not going to have to be it is going to have to be a matter for trial to determine whether this case is one of making matters worse. And then at 8, you can, if you just mark 8, and then again the relevant section where she deals with Arundel is 15. So I don't want to be any further diverted from my route, but given that your lordship raised it, I thought I'd deal with that point first. So if I go now to the our first submission, which is, we say, the high principles. The first point to consider is Michael Robinson as confirmed in Poole, what did they decide? Now we say as follows, the following principles are clear, and we've reduced them to, I think, 4 propositions. The first is that a public authority, in fact, I'm going to be referring to Poole and Robinson. So the public authority may owe a duty of care in circumstances where the principles applicable to private individuals would impose a duty unless inconsistent or excluded by legislation. Not applicable here, whilst the police are effectively, as I understand it, exercising common law functions, which derive from, I think, their oath. Some of this is dealt with in the history in the Michael case. Their oath, their duty to protect property and life, investigate crime. And it's, although there is an awful lot of statutory material surrounding powers of the police, the ultimate expression of why they're there in this context is rooted in the common law. It is a public, it has a public law flavour. And that's, and of course, there are private law implications, which is why suing the police has always been such a controversial exercise. Now, we see that from at AB 505, which is Poole. So if we just pull that up. I'm not going to go through these cases in any great detail at all because he spent so long looking at them. But paragraph 65, that's summarising what's said in Robinson at 32 to 33. The reference to that, don't look it up, but the reference to that is AB 452. So it follows that public authorities may owe a duty of care in circumstances where the principles applicable to private individuals would impose such a duty, unless such a duty would be inconsistent with and is therefore excluded by the legislation from which their powers or duties are derived. 2, that public authorities do not owe a duty of care at common law merely because they have statutory powers or duties, even if by exercising their statutory functions they could prevent a person from suffering harm. And 3, that public authorities can come under a common law duty to protect from harm in circumstances where the principles applicable to private individuals or bodies would impose such a duty, as, for example, where the authority has created a source of danger, that's an example, or has assumed a responsibility to protect the claimant from harm, unless the imposition of such a duty would be inconsistent with the relevant legislation. That's the first proposition. The second, and here we go to paragraph 28 of Poole at AB 494, numbers bottom right. Public authorities do not generally owe a duty of care to confer benefits on individuals. That's the omissions principle. And let's look at that again. Like private individuals, public authorities did not generally owe a duty of care to confer benefits on individuals, for example, by protecting them from harm. Shepherd and Gloucester, that's the case about lighting. And East Suffolk. In this context, I'm intentionally drawing a distinction between causing harm, making things worse, and failing to confer a benefit, not making things better, rather than the more traditional distinction between acts and omissions, partly because the former language better conveys the rationale of the distinction drawn in the authorities, and partly because the distinction between acts and omissions seems to be found difficult to apply. as in the case of private individuals. However, a duty to protect from harm or to confer some other benefit might arise in particular circumstances, as for example, where the public body has created the source of danger or assumed responsibility to protect the claimant from harm, and then there's a reference to Dorset Yacht and Gorringe. So that's the second proposition. The third proposition is that the law draws a distinction between causing harm, making things worse, and failing to confer a benefit, not making things better. And this is preferred. I mean, it's really part and parcel. It's referred to in the second proposition as well, but more preferred to the more traditional analysis based upon differentiating between positive acts and omissions. Poole, again, paragraph 28. We've just split those up. A reading, I'm sure you'll reread these, the relevant sections of these authorities before you give judgment, but you will notice, if you go back and look at Lord Toulson, that there are constant references to pure emissions. So that the emissions principle, that you're looking to exceptions when it's a true do-nothing case. This is, in fact, one of the points that is still at large. In Gorringe, they did absolutely nothing. In Stogan, they did absolutely nothing. The attempt to extract or create the common law duty of care was reliant entirely on the statutory power, and that's what you can't do. Fourth proposition, if overall a court decides that it's a failure to confer a benefit case, there will be no liability unless one of the relevant exceptions applies. And we say, and this is the first big, if we understood the dialogue between my learned friend and the court, is that these exceptions are conceptually distinct from making matters worse, from causing harm. They also give rise to a duty. Poole, paragraph 28. And further to bolster that, we say the exceptions to the absence of liability in such a failure to confer a benefit case cannot logically require satisfaction of the other category, which is the making matters worse, causing harm case. You've got to take a macro...
Did your headline submission, was it, if the court decides that this is a not making things better case, then there are exceptions? Is that, which are conceptually distinct from making matters worse?
Well, you've got to draw a distinction. Robinson was a case all about a lady who was knocked over when she was just minding her own business, walking down the road, drug dealer, arrested, knocked over. They actively cause harm. Yeah.
They created the danger.
They create the danger, they cause harm. It's not a failing to confer a benefit case.
So, on normal tortious principles.
Yeah, exactly.
If they'd been individuals, they would have been liable.
It's another example of Rigby, Knightley and Johns, the cases that you see that Lord Keith referred to in Hill. You then got to look at what happens if there's an omission, to use the old language. Because let's not forget, which often does sometimes get forgotten, one of the huge developments as a result of Robinson was the clarification that the Hill immunity is not a global sort of protective cloak, or the Hill rule as it's sometimes called, we and the judges were calling it an immunity, that they are immune for pretty much anything they do in relation to the investigation and suppression of crime. And so it grew like Topsy, and it grew way beyond what was the original plan of Lord Keith when he gave his famous judgment in Hill. And it was re-explained as there's no special rule that applies to the police. We're all the same, private, public bodies. The real reason for treating these dreadful cases, and there have been so many in the news recently, they're always in the public domain, are failures of this public authority, failures of that public authority, failures of the Metropolitan Police in relation to the dreadful events that have happened recently. There is generally no liability on the police to protect anybody else. because of the general rule that we've looked at, the omissions principle. The failure to confer the benefit category, preferred language, because I'll get to it in my note, Lord Hoffman's explanation, which I think you looked at yesterday. If you don't keep a proper lookout or touch the brake, it's an omission. Or is it? Is it not actually an act? Or sorry, yeah, it's an omission, or is it an act? And what he says is it can plausibly be said by the person into whom you drove that it was a positive act of a collision. So the whole purpose of what they're doing is to move away from acts and omissions searching for positive acts. You've got your positive act in one category, but when you come to your analysis of the exceptions, you do not mix and match. Because there was I think what we particularly took note of was, I think when my Lord Justice Stuart-Smith said to Mr. Warnock, well, there are two categories of liability. I mean, I'm jumping ahead of myself here, but I think what you said was, well, is it right that you've got making matters worse, but then also if you've got an argument about, I think you said assumption of responsibility, you don't get into assumption of responsibility unless it's a making matters worse case. That is an absolutely...
If I said that, that was wrong.
It's a fundamental misunderstanding of the law.
Yeah, no, if I said that, that was wrong.
Good. Well...
There's two strands of authority. One is making matters worse. Simple.
Well, causing harm.
Causing harm. Yes. Causing or exacerbating harm. And the other is the limited cases where, well, the second is where a private individual would be liable in tort. If you don't think make matters worse, there's no duty unless one of the exceptions apply. Yeah. I think there's a danger of making this much more complicated than it really is.
Let me just
stick to your notes.
Just go through where I got to, just to keep it with less words on my part at least. So there's a conceptual difference between causing harm, making matters worse cases, which give rise to a duty as we've explained, and then the exceptions to the absence of liability in the failing to confer a benefit type case cannot logically require the satisfaction of anything to do with making matters worse. So there's no sort of cross-infection of the two, which is certainly, I mean, your lordship said it, maybe it was a bit of misspeaking, but it was gobbled up by my learned friend. And we have to sort of shoot that goose or fox or whatever the metaphor is. So the exceptions are best expressed, let's look at the exceptions now. The exceptions are best expressed at paragraph 76 of Poole, 509A to B. The second consideration on which Lord Justice Owen, so here he's dealing with Court of Appeal decision. Second consideration on which Lord Justice Owen based his decision, namely the principle that in general there is no liability for the wrongdoing of a third party, even where that wrongdoing is reasonably foreseeable, is plainly important, but, as he recognised, not conclusive in itself. In Robinson, this court cited at paragraph 34 a helpful summary by Tavares and Steele, negligence liability for omissions under the police, of the situations in which a justification, I don't want to put too much emphasis on this because law reports or judgments are not to be read as statutes, but it is not without significance that he uses the word commonly. Commonly exists for holding that the common law imposes such a liability. So it's what I said earlier on, there has to be a balance struck between when public authorities are going to be protected from potentially, all this is gone now with policy and floodgates, but the old thinking was, you've got to protect them and their resources from being sued in court by too many people, too expensive, bad idea, not in the public interest. there's a controversy still because of what Mr. Warnock told you yesterday about Lord Mance and Lord Hughes's preferred approach, which wasn't strictly a dissent in Robinson, but they put different, they agree, but they put different emphasis and say that policy can still come in. But commonly exists for holding that the common law imposes such a liability. Then he sets them out. Assuming responsibility to a claimant, so in the tort of negligence, a person A is not under a duty to take care to prevent harm occurring to person B through a source of danger not created by A, i.e. if it is created by A, you're in the other category, unless 1, A has assumed a responsibility to protect B from that danger. A has done something which prevents another from protecting B from that danger, so here protecting the claimant. A has a special level of control over that source of danger. And then finally, the defendant enjoys, or A's status rather, creates an obligation to protect B from that danger. So that's the exceptions. Then we get to our 5th proposition, and that is that Caparo, or dealing with the Caparo issue, we only consider what's fair, just and reasonable, which does import all of the policy, multidisciplinary resources, policy, defensive, encouraging defensive behaviour, etc. Only consider those in a novel case where established principles do not provide an answer. We say this is a case where established principles do provide an answer, and there's no need to consider what's fair, just, and reasonable. And I think you were taken to the sections dealing with this in Robinson, which I won't go back to. But as we understand it, and in our respectful submission, this is a correct description of the law, the Robinson approach is based on where the law has been, precedent. You look at the territory that, in this case, the law of negligence has occupied before. You look for positive examples which are preferably on all fours factually, or close enough. And then you look at, through the process of incrementalism, you look at whether or not it's straining established principles already there in the cases to say, well, yeah, we can apply that because it's just a bit of a fairly crab-like movement to the left or the right. It's not too bold a departure. That doesn't involve policy, but I think there is a section in Robinson around about paragraph 32, 33, I think from memory, which says, well, that's really that does import a degree of looking at the justice and the reasonableness of whether or not you should make that step. But it's not a full-blown Caparo exercise. So
that's all I can say, Mr. Byrne, is that's not my reading of what they say. What is now established by Robinson is that fair, just, and reasonable as an element of Caparo was not intended as a universal test or part of a universal test.
correct.
It only comes into play if established principles and looking at you're within established categories of liability. If you're not, then fair, just, and reasonable, which imports all the things that you've just referred to, may come into play as appropriate.
In a novel case.
In a novel case, in deciding whether to take an incremental step, namely whether to step beyond whether to step beyond established categories.
I'm not sure. I'll turn around for a moment and just check with my learned friend behind me. But I think that particular debate is not something that is key to the problems that we face in this case. So,
I think I agree.
if I could just, maybe just sort of pause for thought on that point. But I don't have at my fingertips the precise part of Robinson that I was referring to, but it may well be that, maybe 5 minutes or so after lunch, I can go back to that if I need to. But I think that may well be the difference between us. Right, so...
Sorry,
then,
can I get, Mr. Byrne, can I just get this absolutely right?
on this particular point, what do you think is the possible difference between yourself and...
I'm sorry, my hearing loop isn't working, sir.
No. Is there something we can do to better assist the working of your hearing loop, first of all?
I'm doing my best here, but it's, hold on.
I'm just concerned, Mr. Bowen, if your hearing loop isn't working, is there something the court can do?
Well, I don't know whether it's
to
switched
better
on. It was
assess?
working very well yesterday,
Well,
but unless I haven't switched it on at my end. Yeah, no, okay. It was working yesterday to an almost offensive degree. Switched off, it's switched on. Well, I'm greeted by the delightful sound of silence. I mean, I can just about, I'm sorry about my disability, but...
it isn't for you to apologise for your
Yeah, that's right.
disability. It's for the court to try and ensure that if we have a practical means of assisting you, we should do it. But it's... Do you want to try another hearing loop? Do you want to try another piece?
I'm okay as long as you can hear me, as long as you don't mind shouting at me.
No, I don't mind.
I'm used to being shouted at on many aspects of my life, so it would be just usual thing. I've done Caparo. I mean, I'm very keen to get through this, particularly because of your kindness yesterday. So I don't want to. If I'm really struggling to hear you, I will shout. I'm now going to go to my second submission, which I may well have covered in part. But error one, well, in fact, I've covered this, but I'll read it anyway. That the Tavares and Steele exceptions only impose liability in a failure to confer benefit case if on the facts the public authorities made matters worse. And I think maybe you said if that was what you said, you don't think it's right. Wrong because of what I've explained already. To illustrate this, see Poole, paragraph 77 to 78. Exceptions not underpinned by the causing harm issue. 77 to 78 Poole. Present case is not brought on the basis that the counsel was in the second, third, or fourth of these situations. So failed to protect control status. It was suggested in argument that a duty of care might have arisen on the basis that the counsel had created the source of danger by placing Amy and her family in housing adjacent to the neighbouring family. Then it's set out why that is wrong in reference to Mitchell. The claim against the counsel 78 is based instead on an assumption of responsibility or special relationship, and then the particulars are set out. So they are very plainly, we say that illustrates, they are very plainly separate concepts. Second error, which we were discussing in relation to Caparo. I think, Your Lordship, the note we've got of you, what Your Lordship, Lord Justice Stuart-Smith said was, there are two principles which give rise to liability. If a private person is liable, so is a public authority. That's the first point. And the second, no liability under the exceptions unless the public authority has made matters worse. And I think I've covered it probably completely now. It's plainly incomplete, as liability exists if you're within one of the four exceptions, nothing to do with making matters worse. So we now get on to ground one, setting out our stall, this is the third category, on what constitutes making matters worse. And Mr. Warnock, his central point is that it requires a direct and negligent positive act which creates or adds to the danger. We say that's not correct. We grapple with this at paragraph 23 of our skeleton argument. So turn that up. And really, paragraph 23, I won't read it, but if you just mark that as an important section, what we say that amounts to is as follows. The test requires the court to look at the facts overall, consider according to common sense principles of causation, whether what the public authority did made matters worse. And I'd like to take you there to Lord Hoffman in Stovin at 178 of the authorities bundle, internal page number 945D.
Which tab is Stovin? Just please remind me.
Which
Which
tab?
tab?
Oh, sorry. 5.
Thank you.
And this is where we see the driving example, but I've got to take you to the actual section. And he's referring, if you take it from B, what he's referring to is something that Lord Justice Kennedy said in a previous case, or perhaps it was in the Court of Appeal. Here the Highway Authority did not simply fail to act, it decided positively to proceed by seeking agreement from British Rail, and its failure to pursue that course is not an omission on which it can rely to escape liability any more than a car driver could escape liability simply because his breach of duty consisted in a failure to apply the brakes. I do not find this analogy convincing, as of course it is true that the conditions necessary to bring about an event always consist of a combination of acts and omissions. Mr. Stovin's accident was caused by the fact that Mrs. Wise drove out into Station Road and omitted to keep a proper lookout. But this doesn't mean that the distinction between acts and omissions is meaningless or illogical. One must have regard to the purpose of the distinction as it's used in the law of negligence, which is to distinguish between regulating the way in which an activity may be conducted and imposing a duty to act upon a person who is not carrying on any relevant activity. To hold the defendant liable for an act rather than an omission, it is therefore necessary to be able to say, according to common sense principles of causation, the damage was caused by something which the defendant did. If I'm driving at 50 miles an hour and fail to apply the brakes, the motorist with whom I collide can plausibly say that the damage was caused by my driving into him at 50 miles an hour. But Mr. Stovin's injuries were not caused by the negotiations between the Council and British Rail or anything else which the Council did. So far as the Council was held responsible, it was because it had done nothing to improve the visibility of the junction. So Gorringe is a pure doing nothing case. Second point we make of paragraph 23, causation, i.e. what the officers did or failed to do, was causally linked to the fatal accident occurring. I think that's common ground. Thirdly, the reason for the change in emphasis from acts and omissions to causing harm as opposed to failing to confer a benefit is due to the difficulties in characterizing and then differentiating between what is an act and what is an omission. And that's why I've read you that section. So it follows, the fourth point, it follows that the key to this change must in our submission be that you take a wider look, a macro look at the scenario as a whole, and you don't do what my learned friend is doing, which is seeking to carry out a granular examination of the individual aspects of the conduct.
I don't understand. I'm very sorry, Mr. Byrne. I just don't understand what you mean by that.
Well, he gave a whole series of examples about the sort of positive act that would be necessary in order to establish liability. I mean, I'll develop this as I go on, and we'll look at questions that haven't been asked and you've seen what the pleaded case is, but you have to look overall at the situation about what would have happened had the police not turned up, and that falls in to the to the structure that we say you see from Gorringe, and that there is in order to make sense of this, you have to have a wider, and from capital counties as well. You just let me go through it. I hope the point will be illustrated as we proceed. So, the making matters worse analysis replaces the need to differentiate between positive acts and omissions. And our submission is that it's therefore no longer necessary to search in this granular fashion for what does or does not amount to a direct and positive act. And in sort of temporal terms, when it happened. I mean, because at precisely what stage the rescue was at, and all of the interchanges that we had yesterday, particularly in relation to OLL. So the overall scenario in this case, and in this type of case, will involve a multitude of acts and omissions, as we have pleaded. And it all culminates in the negligent removal of the signs, one of our absolutely key points. And could I just give you the reference to the supplementary bundle 45? The fire service as well, when they were effectively released by the police, we know from Mr. Thames, can we just have a quick look at it, supplementary bundle, page 45, that they put up their own sign. It's something I only noticed fairly recently. And it's hidden away. It's admitted in the defence by Mr. Warnock, passage in our pleading where we say that I think it's PC Stamp puts the sign out and he then takes it away again. There was only one sign in the car, not two. That was all covered in the inquest. Well, there was another sign as well, and that we see in the second statement of Peter Thames, and it's the bit that begins in respect. In respect of the equipment, so this is 1, 2, 3, 4, 5, about 8 or 9 lines down, halfway down the page. In respect of the equipment that we had at the scene, on arrival at the scene, we deployed one sign at the rear of our vehicle. This could have been either one saying police slow or one saying police accident. When we left the scene, we collected up all our equipment, including the sign, and left. So there were two. One of the things when I go through my questions of what we don't know, the sort of unknown, the sort of known unknowns, quite a lot of it relates to what would have happened had the police not turned up but the fire service turned up. What role would the fire service have had in the absence of the police? Can that constitute adding to the danger, falling into what we say is a wider macro test, not searching for what we, for instance, see in Daly, which is the positive directive just to stop the rescue, or the obvious turning on and off of the sprinklers in capital and counties. Those are all examples of cases which fall within a causing harm, making matters worse case. But the concept is not limited to that. Now, if contrary to that submission, on what we say is a wider or macro test, we have to identify a negligent causative positive act, we submit that our pleaded case is more than sufficient for the court to find that it's not bound to fail. And we say because aggregating everything that we've pleaded, together or leading to the culmination in both the removal of the signs and the departure of the fire service with the removal of their sign, and crucially the loss of the volunteer rescuer, who would, we know, and even if it's a strike, we're looking at it on even if we're just looking at it on assumed fact, and we've got what Mr. Kendall says in his witness statement, that he would have remained there. He would have done his absolute best because he knew what had happened to him.
But how can that be? How can that be a basis of liability for the police? He was taken off in an ambulance. There's no suggestion that he was directed to be taken off by. There's no suggestion he was.
Well, that is. I'm going to take you to a hypothetical versus real scenario in capital and counties. So if we could just pause that question, I will come back to that. Okay. That's what happened. What, with the greatest of respect, your lordship is not focusing on at the moment is how you've got to look at what happened and then compare it to what might have happened. That's the whole concept of, and you see that from East Sussex. They didn't, no, sorry, East Suffolk, sorry. They didn't have to turn up at all. But if they did turn up, and they're negligent, no liability, they're only liable for damage that has occurred, fresh damage that has occurred as a result of them turning up. But you compare that to what would have happened if they hadn't turned up at all. And that's what we see, that's the theme that goes through Stoving. So, and it is consistent with Lord Justice Stuart-Smith's analysis in capital and counties. I won't go out of order, unless I'm about to get there anyway. I might be about to get there anywhere on the note. So you can't say that just because he was taken away by the paramedics because the police were there, if he hadn't made that call, he's waving, his evidence is I'm waving, gesticulating wildly, and there's the van which we've pleaded it slows down. If the police service hadn't existed, let's say, or if he couldn't have got through, or if he'd phoned up and they'd said, as sometimes happens in these appalling domestic violence murder cases, I'm sorry, love, do you mind if we come tomorrow? You know, that sort of thing. I mean, I've had cases on with exactly those facts. So they don't come. What happens if they don't come? Well, we can't say for sure he would have been taken by the paramedics straight away. And then I'll get into the hypotheticals in due course. But his evidence is, and at the moment, on the basis of a strikeout, we're stuck with the evidence and the pleading. Can't go back, cardinal sin to go behind the pleading, unless you say it's all completely fanciful and it's bound to fail.
But that's seeking to impose liability on the police simply for turning up.
No.
Yes, it is.
No.
Because as I've understood the case about Mr. Kendall, the potential possible case about Mr. Kendall, it's if the police hadn't turned up, I would have gone on waving.
No. No.
There's no pleaded case that he was directed to be taken away. It was at its highest. He decided to allow himself to be taken away by the ambulance because the police were there. Yeah.
With the greatest respect, my lordship, there is a huge difference between us here. I say there's a huge difference between Lord Justice Stuart-Smith and Lord Justice Stuart-Smith as well.
Well, it's an
and a son disobeys his father at great peril. But the case that Lord Justice Stuart-Smith was dealing with, capital and counties, did not have an existing rescuer. That's, with respect, what we say at the moment that your analysis is missing. Because if we're right about the macro, the wider approach, you cannot ignore the fact that Kendall was present. That is not a constituent part of the analysis in capital and counties.
I'm allowing for the fact that there is someone who can be described as a rescuer present, Kendall. Mr. Kendall is present. I accept that.
Yeah. Well,
and I accept that when he's not on the phone to the call, so he has waved to people to slow them down, and he has stated that he would have wished to go on doing so. But there is no allegation that the arrival of the police did anything more than arrive. There's no allegation that they directed him to stop. There's no allegation that they said to him, don't worry, we're now taking over. There's no allegation of any representation at all.
Well,
so I stick at the moment with the suggestion that what you're trying to do is to impose liability on the police simply for turning up.
Well, that's not our case.
No, well,
that's not our case. And we will check the pleading. A cheat answer, or not a cheat answer, but a real answer, but a bit of a cheeky answer, is that it's very well known that if there is if on a strikeout, if there's another way that the case can be put, courts would allow an amendment. So, and I am quite sure that in a case like this, your lordships and your ladyships are not going to say to me, it's a really important case, both forget the individual tragedy of what happened, but a really important case legally. This could never be decided against me on a pleading point.
I don't agree. Well, subject to what my lady's going to say.
Sorry, you
I
don't
don't agree. If you want to run a different case, plead.
well, we can.
Mr. Bain, I think the point is this, isn't it? That all these points ultimately go to a fact, that this is not a strikeout on pleadings. This is a case which needs to be heard on its facts,
Correct.
so that a full picture can be ascertained by the court, findings of fact made, and on the basis of those findings of facts, then determinations of law.
Exactly. And if, and of course, that's our case. And if, as a result of a trial, it turns out that there is still a really real problem with the law, then the case then proceeds up the hierarchy, as has happened before. Vendanta, Begum, etc. That's a much, much better route than doing it in this manner when there is so many, I can't remember the full Donald Rumsfeld quote, but the known unknowns, etc. Capital and counties, we entirely accept that they don't have to take the call. It doesn't matter if they get lost on the way, and it doesn't matter if they run into a tree. But it does matter here because the police attended, and by dint of their attendance, a whole different scene played out with the loss of somebody who we say, and also the fire service, and maybe now might be quite a good time to go through my list of questions, would have avoided the accident. And I can at this stage say would have avoided, not might have avoided, and get into standard of proof exercises because of the position we've got on causation. And also, and I'll pick it up in the note in a moment, the burden of proof, as we understand capital and counties, is when we get to this comparison between what happened and what might have happened, the burden is actually on Mr. Warnock to establish that the position wouldn't have been better. And I get that, that's clearly stated in capital and counties, and I will, without further ado, go to it. So I'm now on capital and counties. You were taken in detail through the case, so I'm going to take you to, I hope anyway, to one passage, 1034C to E, which is at 103, page 222. I'll go through my note, but I think I've made some of these points. It's just a narrow example of a particular set of facts. I'm not in any way minimizing the importance and significance of the judgment, but it's quite straightforward. In Hampshire, they just turn them on and turn them off again. Sorry. They turned them off. They were already on. So they positively made the position worse. But Lord Justice Stuart-Smith tells us at 1034C to E that you've got to compare two scenarios. And I'll read this. It starts with, we do not accept Mr. Mumby's submission. That was a submission on the evidence. The danger with fire is that unless it can be controlled and prevented from spreading at a relatively early stage, it will quickly become out of control and consume all in its path. That danger was particularly acute, having regard to the construction of the roof at the Crescent. Having negligently turned off the sprinklers, which were at that stage containing the fire, the defendants, by their positive act, exacerbated the fire so that it rapidly spread. The question is thus one of causation and has to be tested with the benefit of hindsight by comparing what would have happened if the sprinklers had been left on with what in fact happened. This is what the judge did. He was correct to compare one hypothetical situation with one real eventuality, rather than two hypothetical situations. It is not to be supposed that having arrived on the fire ground, the fire brigade would simply have sat on their hands. And then the burden of proof point we see just by letter F. I don't think I need to go to the first part, which is all about East Suffolk, or the true analogy between Hampshire and East Suffolk, and then he gives the example. In such circumstances, the defendants would at least prima facie be liable for the extra damage unless they could show, and the burden would be upon them, that the damage would have occurred in any event, even if they had never come upon the scene. If they were unable to discharge that burden, then they would be liable. Similarly, in the present case, the judge's inability to make such a finding in their favour must, in our view, render the defendants liable. So that's exactly what we are saying in relation to what would have happened had the police not attended at all. Findings are needed, as already submitted, as to what Kendall would have done and whether Mr. Warnock can establish, the burden being on him, that the accident would have happened anyway. That, with respect, is the correct analysis. Now, right, just a few words on Smith and Littlewoods, which we haven't looked at. That's at tab 3, just so you're reminded of it. It's a very well-known case. Different type of case to the instant appeal, 104, but just worth a very quick look. There are two major speeches, Lord Mackay and Lord Gough, but it's Lord Gough's speech that has attracted subsequently, I think, the approval of subsequent appellate courts. Because his analysis was all about the omissions principle. This is all about a duty on an owner of a disused cinema to guard against the risk of fire by trespassers. And the case involved obligations of a landowner to protect neighbours from deliberate wrongdoing. And if I just give you the reference there, 273D2F, page 136. And the analysis chimes with Michael and Robinson and the general rule that the property owner is not liable to adjoining occupiers for the acts of the third-party fire setters. That's 271C to D. Never go back to that. And you see there, C2, that's just another expression of what we've already looked at, the omissions principle. But just have a look, and again, I know, I don't mean this as a jury point at all, but it is worth looking at for somebody as celebrated as Lord Gough, in relation to what we say is the degree of discomfort that some may feel about the general rule, 271E2A. Lord Diplock, so he's dealing with Lord Diplock's approach in Dorset Yacht, then proceeded to give examples which show that carried to extremes, this proposition, i.e. the omissions principle, which the courts have now accepted as the general rule but reset with exceptions, may be repugnant to modern thinking. It may therefore require one day to be reconsidered, especially as it is said to provoke an invidious comparison with affirmative duties of good neighbourliness in most countries outside the common law orbit. But it is of interest to observe that even if we do follow the examples of those countries, in all probability we will, like them, impose strict limits upon any such affirmative duty as may be recognised. In one French decision, the condition was imposed that the danger to the claimant must be grave, immediate, constant, etc. So what he's saying there is that, yes, there's got to be a strict approach, which is exactly what Lord Reed is saying. But he is saying that, it's a look at the two powerful, passionate dissents in Michael. And all I am saying, the reason I get to this is to drive home the point that whilst a strict conceptual approach, which is based upon East Suffolk and is consistent with the old and celebrated principles of the common law, and that we've gone sort of up and down through policy and made mistakes with hindsight, they have left a considerable gap through to Faris and Steele. And of course, how one is going to set and how strict one is going to set the test for making matters worse. So there are the two sort of two different sides of the equation. And what we say is the core, one of the core problems that is going to have to play out. It's playing out in numerous cases, I've said, in the child protection field, and this is just another one. So, and I won't repeat what I've already said about the fact that it's a strikeout. So, he then talks about, he then gives a hypothetical example. So just to reorientate myself, 272D to 273C. He there goes over, that's his analysis because there's a private law case. East Suffolk was against a statutory authority. This involves private individuals. So I won't go through it now, but it's probably worth you looking at that. We then get to a section just above 273 F to G, which has some analogy with the making matters worse test. And the test he puts at F is, it is in my opinion consistent with the existence of such liability that an occupier who negligently causes or permits a source of danger to be created on his land and can reasonably foresee that third parties may trespass upon his land and interfering with the source of danger may spark it off, thereby causing damage to the personal property of those in the vicinity, that they should be held liable to such a person for damage caused to him. And then the duty to the neighbour at H. Then he gives his hypothetical here about Guy Fawkes. He stores them as usual in an unlocked garden shed, abutting onto a neighbouring house. It's well known that he does this. Mischievous boys from the village enter as trespassers, play with the fireworks, cause a fire, spreads to and burns down the neighbouring house. Liability might well be imposed in such a case for having regard to the dangerous and tempting nature of fireworks. Interference by naughty children was the very thing which in the circumstances the purchaser of the fireworks ought to have guarded against. But liability should only be imposed under this principle in cases where the defender has negligently caused or permitted the creation of the source of danger. And we submit that by analogy here, the police have permitted the continuance of the danger by acknowledging the risk. And this is where there's a merger, I suppose you might say, because just pausing there for a minute, we know from Caparo and what they say about the law of tort and labels, that they're only labels, and that in many ways the law of tort is replete with examples of how there are different ways of saying the same thing. So you can, I mean, this is why I was talking about assumption of responsibility and control. You can sort of have a bit of a collapse to some extent, or query the extent to which assumption of responsibility might be looked at in terms of control. We'll see this when we look at A.J. Allen. But they come in, they control, they relinquish control. So here,
so you were halfway through a sentence, which I think started, by analogy, the police have permitted the continuance of the danger by...
Well, they permitted the continuance of the danger by acknowledging the risk to oncoming motorists, erecting and then removing the warning signs. Along with, they're my macro analysis, telling the fire service that they can go and then they take their signs. So Lord Gough, if this is analogous, is getting at a similar concept, knowledge and creation of the danger. Like the negligence purchaser of the fireworks, there's no doubt that on our pleaded case, the police knew or should have known of the localised deadly ice hazard. But
the landowner creates the danger in the first place by storing the fireworks.
No, I accept that. No, I accept that it doesn't run completely. I accept that.
Okay.
So, as found by the master, actively attending and placing and then removing the sign, the attendance inevitably led to Mr. Kendall ceasing his efforts to warn the traffic and agreeing to go in the ambulance. That may well, on the facts, amount to a sufficient...
Sorry, Mr. Byrne, hadn't he already...
That made matters worse.
Mr. Byrne, hadn't he already stopped? I mean, he wasn't stopping...
Say again, sorry?
He wasn't... Mr. Kendall wasn't stopping the traffic, was he, or trying to stop the traffic when the police arrived?
Yeah, I accept that.
So, I'm not sure how those two things are linked. I appreciate the police arrive, but they don't know what he's doing. There's no evidence that they knew that he'd been trying to stop the traffic.
No. Well, we know that the call handler. I think. Could you bear with me a moment? I think there is a pleading that they did know.
All right.
I think there's a pleading that they did know because there's something in the transcript about what the call handler, what Mr. Kendall told the call handler.
All right.
We'll,
Well, I can
we'll
check
give you
that.
the.
Yeah, thank you very much.
Give you the reference. So then that takes me on to my fourth submission. It's very glass. You have glasses. You have to forgive me if I swig from the bottle. Right.
Yes, I'm not sure.
That's COVID.
Yeah.
Just to let them know, Cotter are going to bring some new batteries for your hearing loop.
No, they're only for this
Yeah,
one.
Yeah,
Is that the problem?
I think so, yeah.
Oh, I see. All right.
They're going to bring some down.
Oh, I see. Right. Okay. We have a battery crisis. Right. Alternative case, assuming it's not a causing harm, but a failure to confer a benefit case, we say we are then into Tafaris 2, which I have touched on already. Just like my Lord, Lord Justice Stuart-Smith's decision in OLL at 906B, and that you see at page 249. The Coast Guard's misdirection of the search by the Navy helicopter and ditto the prevention or neutralising of Mr. Kendall engages that exception as set out at paragraph 76 of Poole. Just going back to the pleaded point, paragraph 22, core 72, Mr. Kendall spoke to the first defendant, civilian call handler, one David Wilkie, and gave the facts of the accident, that his back and chest were hurting, and that he had tried to flag down a van, that the van slowed but failed to stop. And that was, there are boxes and boxes and boxes of papers, a 5-week inquest that we had to go through, or that I went through, when the case was pleaded.
And that's why I've rather assumed, if I may just say so, that every possible fact that could be pleaded has been pleaded, and it certainly reads as though it has been.
I pleaded it, but
Yeah.
but that still doesn't answer. I can plead the real stage of Lord Justice Stuart-Smith's analysis, but we can't assume the second hypothetical stage of what would have happened had they not turned up. That's where the Vendanta Begum point, I think, on this aspect of the case comes in. But but going back to Tafaris 2, both the misdirection of the helicopter and the wrong search area and the loss of Mr. Kendall and the signs satisfies that test, prevention of another from protecting the claimant, which does not require a positive negligent act, as we are in an exception to the failure to confer a benefit area or type of case. So there's no question of having to satisfy the making matters worse test. And it cannot, we say, be argued that this exception is not part of the common law. Poole, paragraph 76, we've looked at that already.
In your submission, Mr. Bone, OLL was wrongly decided.
Well,
Was it?
I don't think I have to go that far. I obviously say you should have won. But if it were heard today, it would have been decided under Tafaris 2, or it could have been decided under Tafaris 2. And we know, I wasn't planning to take you to it. If my learned friend gives me the reference, I will. Lord Bingham in Van Col, or Van Collie,
Yeah, but he was
had a very, very poor
dissenting.
view.
But he was dissenting.
He was dissenting, but he's Lord Bingham. And just so I don't misquote him, it's at 364 to 365. I won't go through it, but he sets out your lordship's arguments when you're at the bar. They made the position worse, just taking it at the end, they made the position of the party worse by failing to ask the Royal Navy to scramble a second helicopter at 5 o'clock, although they were asked at 4:26 whether a further aircraft was required. Claim was struck out on the basis that no duty of care was owed, and the claim is bound to fail. My lords, I feel bound to say that a law of delict taught, which denies a remedy on facts such as these, is in the absence of any statutory inhibition, or it fails to perform the basic function for which such a law exists. I mean, that's really powerful, which needs to be reread, or rather needs to be taken into consideration when resetting the facts of OLL to a post-Robinson Poole position. So I would love to say that it was wrong and you should have won, but I don't think I need to. All I need to say is that it's in no way a roadblock to our arguments, because irrespective of what we've already gone through on making matters worse, there has to be an arguable equiparation between what happened there and what happened here and what might have happened here. And I read into that everything I've already said about Begum, Vendanta, strikeout, summary judgments, need for a trial, etc. Right, so I've said it can't be argued that the exception is not part of the common law, Poole 76. What I can also say is that this is the first time the issue has come before the court. Point I've already made, but to put it here in the structure. That does not make it novel, as it's a recognised route to liability in the tort of negligence. And again, sorry this is repetition, but it does require a trial on the facts, given this is a fast developing area of the law. So again, with respect to my learned friend, he cannot say the law is settled. Just cannot say that. The master was quite right. It's all in a state of flux. And then I make my point again on Begum, paragraph 71. One of the most fast developing areas of the law of negligence concerns the scope and extent of the exceptions to the general rule. OLL, I've got a few separate points on that, but I may or may not already have covered. Just for your note, it's our skeleton paragraphs 27 to 30, AB 38. OLL is decided by applying the capital and counties approach and concluding that the case is analogous to sending the fire engine to the wrong address. Thus, nothing could be made worse as they never got there in the first place. Skeleton paragraph 27. Compare that to our case, where I come back to this point time and time again, where the officers come to a scenario where the rescuer is in place, not a putative future rescuer, paragraph 29. And I've already made this point. Anyway, in any case, it's more neatly into Tafaris. Thank you very much. Into Tafaris 2, understandably not considered as pre-Robinson. Extreme caution needs to be applied. That one, that one, that.
You can use if you've got own hearing aid.
Yeah, all right. Okay.
Try that one. You've got your hearing aid in.
I have, yeah. Yeah. This is the beauty of great age. I hope you don't suffer from a similar issue. It at least gives me a chance to think about what I'm going to say next. I hear feedback. Right, yeah, okay. Give me a minute. Speak to me.
Can you hear
hear?
us?
Oh my God. Yes.
Well, I'm very sorry that
No. Please.
had to wait so long.
Not your fault at all. Right. Now, where are we? Right, Ansell. So, Ansell is distinguishable from the present case for the detailed reasons set out at 33 to 35 of the court bundle, paragraphs 11 to 19 of our skeleton. If you could turn to paragraph 13, you'll see the facts there, if we need reminding. So a piece of tubing fell from the fourth defendant's lorry, subsequently run over by the first defendant, ruptures his fuel tank, or her fuel tank, I think, leaving Diesel on the road. Police officers from the second defendant's force noticed the trail of Diesel and followed it to the first defendant's car, and then notified officers of the third defendant's force about the presence of the Diesel. Officer from D3's force also noticed the Diesel, reported it to the Highway Authority. None of the officers returned to or remained at the scene to warn the motorists of the presence of the Diesel. The claimant's wife ran over the Diesel, lost control of her car, and was tragically killed. The claimant sued the four defendants. The second and third defendant police forces applied to have the claims against them struck out as disclosing no reasonable cause of action. The applications were refused and the police appealed. We make 4 points on that, which you see going up to paragraph 19, but I've tried to shorten them. Ansell is a failure to confer a benefit case, unlike, at least on this analysis, the current case, because I do have my Tavares 2 and my control route. There was no pre-existing person in situ seeking to take evasive action to prevent the danger. In Ansell, had the officers done nothing, the result would have been the same. In our case, had the officers not attended, Kendall would have remained providing warnings and averting the accident. Could you bear with me one moment? Oh yeah, I know. Sorry, I'm still in ground one. I thought for a minute. I'm still assuming I've Tavares 2. Of course, I'm ground one. I'm dipping into what is also ground 2 because that's control. So I'm now going back. Sorry, I was confusing myself for a moment. So
Yes, I'm finding that slightly confusing as well. So what are we looking at now?
right, we're looking at Ansell,
Yes.
which is one of Mr. Warnock's cases.
Yes.
And he says there that this case is pretty much, although he accepts that the policy arguments can't run.
Yes.
He says still this is a nail in my coffin in relation to making matters worse and the requirement for a direct and positive act. So this is why we say it's not a blockage. So Ansell is a fail to confer a benefit case, unlike us. No pre-existing person in situ seeking to take evasive action and prevent the danger. In Ansell, had the officers done nothing, the result would have been the same. In our case, had they not attended, as I've said again, Kendall would have remained, provided warnings, averted the accident, ditto the fire service. Ansell, insofar as policy arguments are advanced to rejecting the existence of a duty, can no longer stand. So it's got to be departed from in that sense. It was criticised in a case we're going to look at when I look at control in Gibson. In Lord Hamilton's review of the cases, is where you find the criticism, and that was then cited with approval by Lord Hope in Van Colley, and I'll give you the reference, you don't need to turn it up, paragraph 79 to 80 at page 372 of the authorities bundle. So, and then the fourth point, the concerns expressed about the potentially unlimited scope of the duty in Ansell have no application to the current case, which would impose, we say, a narrow and targeted duty towards a limited class of road users, including Mr. Tindall, in relation to the danger posed by the black ice. So that's what we say in relation to Ansell. And then I come on to what I think is my fifth main heading, which is control. And this is now a further alternative route to liability, insofar as the case is properly falls to be categorised as a failing to confer a benefit case. So the alternative way that the respondent seeks to establish a duty is on the basis that the police assumed a duty to Mr. Tindall by taking control of the scenario, including obviously the road, following the first accident. Now, the control exception, originally Tavares 2 in their 2014 paper, became exception 3 post-Michael but pre-Robinson in the 2016 paper. It applies in a failure to confer a benefit case, explained by Lord Toulson. You were taken to all of this by Mr. Warnock yesterday, 413 to 414 of the bundle. And if you'd like to see it again, I can. That's the way he talks about the two different types of relationships. It'll take a bit of time to go back to it. If you want me to, I will, but otherwise I'll just make my submissions on it. The passage is cited anyway at paragraph 36 of the skeleton, page 40 of the core bundle. So two key relationships are required. Defendant and third party is the first one. So what Lord Toulson called D and T. And then D and C, the defendant and the claimant. And I think it was particularly in relation... Is it D and C? Bear with me a moment. Yeah, I would not wish to comment on Tipping's formulation of the criteria for establishing the necessary set relationship between D and C without further argument. So he's particularly zoning in not on D and T, but D and C. He didn't go further into considering the criteria for establishing that special relationship, since there was plainly no defendant third-party control on the facts of Michael. Now, we contend that, Mr. Warnock contends that neither of the two relations can be made out on the facts of this case, but we say that the determination of both those relationships is highly fact-sensitive. That's the first point. To repeat, the law as regards the test is not settled. Coulson, Begum, paragraph 71. In such circumstances, again, point I've already made, entirely inappropriate to strike out this route to establishing a duty of care without a trial. So we then make some, I hope, relatively short submissions on the relationship between, or both those relationships. We accept that many control cases will have a pre-existing relationship of physical control. That's the classic Dorset yacht scenario. However, that is not a prerequisite. See that from the cases I'm going to take you to. In a case such as the present, where the risk does not arise from a human third-party actor, but from the stretch of ice, that can't anyway logically apply. And support for that proposition is found in Couch. That's the Apex case in New Zealand, the New Zealand Supreme Court, cited with approval at paragraph 99 in Michael. Couch facts are summarised in the skeleton at paragraph 39, page 41. So in Couch, the claim brought by victims of a robbery undertaken by an ex-offender who was on licence after release from prison, who had been allowed by the probation service to obtain work experience at a club where the victims were employed. I think I'm right in saying that there was a murder, without the knowledge of the employer and fellow employees to his background. The Supreme Court of New Zealand refused to strike out the case, and the judgment of Tipping giving judgment of himself and Justices Blanchard and McGrath make it clear that this exception to the omissions principle goes well beyond the circumstances of physical control. And then if you actually turn up the law report, it's all cited in the skeleton, but let's just, for safety's sake, look at the originating passages. Couch is at the back of the bundle, at tab 20. And the passage cited at 39 of the core bundle, the skeleton, is at paragraph 81. paragraph 81 is that the pagination is illegible on ours. So internal number 759. 81. Here the plaintiff seeks to hold the public authority liable for omissions which have allegedly enabled a third person to harm the plaintiff. It is the voluntary and independent conduct of the third person that has been the immediate cause of the loss or damage suffered by the plaintiff. The necessary causative link between the defendant's conduct and the harm suffered by the plaintiff is said to lie in the failure of the defendant to exercise an available power of control over the immediate wrongdoer, or in a failure to warn of the risk of the immediate the risk the immediate wrongdoer posed. Discussion of the appropriate way to determine such a case can usefully begin with the general observation of Justice Dixon in Smith and Lewis, and that's the famous, not quite the Fons et Origo, but a very well-known passage in relation to the general rule. And then we get to paragraph 82. It's important for a proper understanding of Dixon Jay's frequently cited statement to appreciate that his reference to special relations was a reference to the relationship between the defendant, here the Department for Corrections and the probation officer, and the immediate wrongdoer, Bell. Whether the relationship is sufficiently special is conventionally assessed by reference to the concept of control. Did the defendant have sufficient power and ability to exercise the necessary control over the immediate wrongdoer? Unless that is so, it would be inappropriate to impose a duty of care on the defendant in favour of the plaintiff, fulfilment of which necessarily requires that power and ability. And then we then need to look at paragraph 84. In the present case, it is possible that Miss Couch will be able to establish that the department, through the probation officer, had sufficient power and ability to control Bell in a way which would have prevented the harm which Miss Couch suffered. The following discussion will therefore proceed on the premise that there was a special relation in that sense between the department and Bell. Hang on, just bear with me a minute. Oh, sorry, I read through it and I read through it and failed to see the word on which I put particular emphasis, and that is through the probation officer had sufficient power and ability to control Bell. So that is really important, and we'll see what the inner house, what the Court of Appeal in Scotland makes of a very similar problem when you've got when they look at Gibson and Orr, which you know what that's about, and I'll come to it, the similar facts to this case, but about a flooded bridge. And they talk about controlling the scene, coming and going, relinquishing control. I'll have to remind myself whether they actually refer to Couch, but they get at exactly the same concept. And we cite that to show that you don't have to establish a strict, the more traditional prison officer, prisoner, probation officer, Borstal boy, parent, child, whatever it is. So it's a concept which hasn't been looked at in very many cases at all. The only ones we've found are Michael, Couch, Gibson and Orr, and A.J. Allen. And the learned friend hasn't come up with any others. So it really is, Lord Justice Coulson, paragraph 61, really quite cutting edge stuff. Don't strike it out. So I've cited the passages in Couch. Found upon ability to control or at least influence. 103 is the next part of Couch. That's what I was searching for in 84 and couldn't find. Right, 103. In her judgment in Modbury, Gowdren J. Now Modbury, we haven't got it for you, but Modbury was a case where I think there was an assault or a robbery in an unlit underground car park of a shopping centre, and there was an attempt to found liability on the failure to properly light. And I have to look at it again, but I suspect it was whether there were lights that were there in the first place, and all sorts of arguments. But at 103, in her judgment in Modbury, Justice Gowdren made the point that there are some situations in which the common law recognises a duty to warn or take other steps to protect another against harm from third parties. Such a duty, she said, can be owed to a person who has special vulnerability to harm at the hands of the third party, provided the person said to owe the duty had sufficient ability to control or at least influence, so that's an even softer test, the conduct of the immediate wrongdoer. This, of course, being the control relationship to which we have earlier referred. It is that special vulnerability which distinguishes the plaintiff from members of the general public to whom no such duty is generally owed. We should add that in the Sutherland-Shire case, Justice Brennan spoke, as we have done, of duties of the kind in question being owed to the plaintiff or a class of which the plaintiff is a member, thereby recognising that such a duty is not owed generally. I think I've already made my submissions, and it's a pretty obvious one anyway, that unlike Gorringe, a duty to everybody, although that was location specific, we accept that, in temporal terms for years, hundreds of thousands of motorists will have passed through, both on the facts of Stoughton and the facts of Gorringe, that particular stretch of road. But here we are talking about a much more limited scenario, whereby the police have the ability to influence, the power to control what happens on that, I think it was just 100 yards of black ice, which you picked up from the pleading was because of water that was coming from Matbridge Cottage. And it was something which had been, the highway authority had been warned about. And the police had been specifically told by the call handler that there was ice. I'm not going to take you to it because you can read it in the pleading, but Mr. Warnock, for understandable reasons, completely glossed over the fact that these officers, or certainly one of the officers, wasn't quite thrown out of the force, but there were findings of gross misconduct. And then there were similar findings, it's all in the pleading, in relation to the inquest. So all of that caused by less than perfect, to put it mildly, behaviour by the police, on whom the law does generally impose standards of care on the Boland basis. But the answer to this case is not to deny a duty. So
You're making a point about the extent of the class.
Yeah.
I've just got a niggle in the. Don't ask you to deal with it now,
Yeah.
but before we rise, whether it's in Ansell or somewhere else, although it could be said of any road traffic accident that the affected class is simply those who are going to drive down that stretch of road.
Yeah.
Am I not right in thinking that that is not the way that this court has treated it before? It has treated the class as being all road users. If I'm right, perhaps counsel could give us the reference by the end of the hearing or after the end of the hearing. If I'm wrong, if I'm wrong yet again, perhaps I could be told.
Well, sorry, are you talking about the way that the stretch of road was treated in Ansell?
Somewhere.
And
I thought it was
and
Ansell.
any other road cases?
You've taken us to 103.
Yeah.
of Couch,
Yeah.
which I understood you to be, and then you contrasted that with Gorringe, which, as you said, has a wide-ranging class.
Yeah.
And then you said here the class of users, the class is the users of that stretch of road.
Yeah.
The A413 that night.
During a short period of time.
And what I'm niggling about is that I think that approach is different from the approach which this court has taken in other cases, and I think it may be answered.
Well, we'll check. We'll check
check
that. But my immediate reaction to that, if that is the case, certainly not binding. I wouldn't have thought the cases are if anything, it would just be an obiter remark. But those are all just matters of first impression. I'd have to look at the passage.
Mr. Bowen, can I intervene? Can I just clarify this? Because as with my lord, I'm just seeking to clarify exactly what you mean by this class. Do you mean this class of persons who would be using that stretch of road at a time when that area of black ice existed?
Correct.
That's it, is it?
Well, I'll check with. Yeah, and of course, what in your pre-reading you will have seen that one of the excuses that I think PC Stamp made was either of his own volition or something that was said to him by the council or the highway agency operative who he spoke to. Because one of the findings against him was you didn't call the gritter. You should have pushed and been more robust in getting the gritter. You should have stayed there until the gritter came. Now, what was said, I think, by the highway agency was, well, don't worry, it'll all be melted by when the sun comes up, which was, of course, a complete misnomer because it was thick black, as I understand it, was thick black ice, which had been there on a regular basis for the previous few days, if not weeks, which was not just ordinary little bit of black ice caused by the weather. It was caused by an influx of water through either coming from this cottage and a problem or through the culverts and the drains being blocked, which is the case against the highway authority. They're not trying to strike us out. So, and again, criticisms of the police were, you failed to do, it's all pleaded, you failed to do an inspection. You were told by the call handler it was dangerous. There's a lot of evidence about the ambulance service saying, well, it's dangerous. There's the call handler saying, well, if there's another one coming down the road soon, we'll be in big trouble. Mr. Kendall says in his witness statement, well, they didn't seem to be in a hurry. They weren't particularly concerned. They just they sent him off to, he goes to hospital and they sweep the road and then they're there for 20 minutes and they leave. So the element of concern that they had was limited. And the class, to get back to that, relates to those who would have passed until the police had dealt with the danger, which would have been, it may well be that the ice was so bad they should have closed the road until something had been done about it. Or alternatively, until the sun had come up and it had been melted, and until the highway agency had got involved. So it's not. In Gorringe, it's everybody who's passed through for the last 5, 6 years, whatever, between the sign being obliterated and not being put back. It's ditto with the bank of earth in Stone. I just want to accelerate a bit. Right. So as can be seen, it's not just a question of the exercise of pre-existing physical control, but the existence of the available power of control, ability to influence the third party, which has negligently not been exercised or has ceased to be exercised. Taking control, relinquishing control. Of course, the facts of the present case are not immediately on all fours with the other control cases, since in the present case we are concerned with the appellant's officers having control of a scene, not a person, but a relevant stretch of road, having the ability to control or at least influence the outcome. This is just repetitious, the risk arising from the ice. And that conceptual expansion is taken by Lord Hamilton in the Outer House, so the High Court in Scotland, in the case of Gibson and Orr. So now we just need to look quickly at Gibson and Orr. And a point I think I've already made, cited with approval by Lord Hope in Van Col 371372 of the core bundle, of the authorities bundle, I assume that is, paragraph 79. So facts of Gibson set out in the skeleton at 44 to 45. Sorry, 49 to 50, forgive me. 44 to 45. Take it from paragraph 50, or paragraph 49, facts of the present case, analogous and consistent with Lord Hamilton. Chief Constable sued after a car in which the claimant was a passenger drove off a collapsed bridge. Following a heavy rainfall, a bridge carrying a public road collapsed. 2 police officers attended the north side of the bridge, and the division which served the area of the south of the bridge was contacted. The constables coned off the north side of the bridge, positioned their vehicle with its blue lights flashing. The constables left the scene without having received confirmation that any barrier or warning sign was in place on the south side. Shortly thereafter, the car carrying Gibson approached from the south side. The driver and other passenger were killed. And then, if we get the authority, Gibson and all you see at tab 18, and we need to look at so here we have, it's an inanimate hazard as opposed to control over a third-party human being. And the relevant sections are 433B to D. Let's read that first. Once a constable has, in exercise of such a function, taken charge of a particular road traffic situation, which without control by him presents a grave and immediate risk of death or serious injury to road users likely to be affected by the particular hazard, it would seem, at least on first impression, consistent with the underlying principle of neighbourhood for the law, to regard him as being in such a relationship with such road users as to satisfy the requisite elements of proximity. This, of course, remember at all stages, is a pre-Robinson Pool analysis. The logic of the defender's argument on proximity leads to the proposition that if constables coming during the hours of darkness happen upon an unlighted major obstruction on a public road, take appropriate measures to warn oncoming traffic of the hazard by positioning their vehicle with flashing warning lights or otherwise, they may thereafter, without being in breach of any duty of care to any road user, carelessly, without instruction or any other reason for doing so, choose to withdraw all such warnings, with the result that road users are once again exposed to the grave and immediate risk. I find that proposition prima facie unattractive. Then he deals with, I mean, I'd ask you to read the next section, E to F, in your own time, but I won't go over it now. I then jump to 433H. Just below G, persons of a limited class defined by their obvious exposure to an immediate and direct hazard may equally be owed such a duty. Persons whom a Borstal officer could reasonably foresee had properly situated in the vicinity of the place where Borstal trainees were staying were held to fall within such a limited class. So there is a true analogy between the position here in terms of the definition of the class of people to whom a duty is owed and Dorset Yacht. And Dorset Yacht was only a property case. I mean, this is a case involving human life. And when we see A.J. Allen, there is not a point that I just float so you know it's there, but I don't think it's particularly crucial to our argument, is query whether at some stage of the law might decide to say, this may or may not be a Supreme Court point, that there should be some distinction between threats to human life and threats to property. That's something that we do see in some of the authorities, and it may be that that has to be by the creation of a further exception, which Lord Toulson, around about, I think, may or may not have been around paragraph 99 of Michael. You were taken to the section, I think, by Mr. Warnock. But he does say it may well be that the court, that the law has the ability to be able to create another exception, which is, I suppose, exactly what happened in Robinson and Poole when they embrace Stelios Tafaris's analysis. But getting back to this, so reference to Dorset, York, Pearl, or Diplock. Certain similarities of that case with the case before him were noticed by Lord McCluskey and Wilson. Persons travelling by vehicle on the public road towards the collapsed bridge in late afternoon in midwinter in central Scotland were, in my view, likewise, as regards the constables who had taken control of that hazard, within such a class. It is not, in my view, a relevant distinction that in the cases referred to, the control had by the officers was of human beings, likely themselves to suffer damage or to inflict it on others, while in the present case it was of an inanimate hazard to human beings. I should add that I do not regard the circumstance averred by the pursuer that he was at an earlier stage aware of a police presence in the vicinity of the bridge as being material for the present purpose, nor in my view is the fact that he happened to live locally a material consideration. And then, so I think that's all. Yeah, I think that's all from Lord Hamilton. So Lord Hamilton, and that has been accepted by Lord Hope. I was just wondering whether it was also looked at by Lord Bingham, but I'll have to check that. So we accept that Gibson predates both Gorringe and the recent trilogy of cases. However, Gibson is plainly distinguishable from Gorringe, since Gorringe did not entail the relevant defendant taking control of the known serious hazard, but the non-repair of a sign which at some point in the past had been painted over. Gorringe does not engage at all with what became the Tafaris exceptions. It's not a case on control. Gorringe, unlike Gibson, and indeed the present case, represented an attempt to make the relevant authority liable to the road-using public at large, as opposed to, I gathered this, sorry, time and location specific, a limited set of potential claimants, and that is relevant to the second relationship that Lord Toulson talks about, D and C. Now, Gibson was approved by 2 of the 3 inner house judges in a later case.
Before you go there, sorry, Mr. Byrne, before you go there.
Yeah.
What is the distinction between putting up a sign which says slow and taking it down, and writing on the road slow and letting it disappear? In terms of control.
Because, I think about that, but I think my first reaction is that because in Gorringe, they historically have a sign saying slow on the road. Mm-hmm. There is then, nothing is done. I mean, if you take the facts of Stovin, there's a decision to do something. They know about the problem. They make an executive decision to remove the bank, but they just don't get around to doing it. Both cases are actively cases of inaction. This case, within a completely collapsed time track, is they attend, they put it up, 20 minutes later, they take it down. So that's positive action. That's taking control in a real common sense fashion and relinquishing it. There is no analogy at all, I say respectfully, with the doing nothing cases.
Well,
this is a doing everything case.
Your use of the word relinquish is very telling, surely. in each case they relinquish the step that they have taken to warn road users.
Yeah. And that's a point for us, not against us,
Thank you.
I think. Right. So that takes me to A.J. Allen. A.J. Allen was a fire case. You find it at tab 19. You see, just look at the head note. Owners of a farmhouse called the fire service, page 612 of the bundle, to attend a fire that had broken out from the stove in the kitchen. The fire service attended and extinguished the fire. So it's one of these, like the Capital and Counties reignition cases that lost. In the early hours of the following morning, the fire reignited and the farmhouse burnt down completely. The owners sued the fire service, alleging negligence on the part of the firefighters in failing to use a thermal imaging camera to locate any areas of concern and to maintain regular checks to make sure the fire had been truly extinguished. The fire service sought dismissal of the action as irrelevant on the basis that it didn't owe a duty of care to the owners of such a scope. Following a procedure role debate, I'm not quite sure what that is, maybe that's just the strikeout process, the Lord Ordinary allowed a proof before answer to go to trial. The fire service reclaimed, applied to strikeout, held that the fire service owed a duty of care to the general public, including the owners, but that duty was to not negligently add to the damage which the owners would have suffered if the fire service had done nothing. In other words, a duty not negligently to inflict a fresh injury, and since no breach of that duty of care was averred to have occurred, and in the absence of averments disclosing anything amounting to an assumption of responsibility on the part of the defenders, the case was pled. The case as pled was irrelevant. Actually, let's look at the observations for Lord Drummond Young. I was referring to the distinction between human life and property. The distinction might properly be drawn between injury to the person and damage to property, and in an appropriate case where action could be taken without danger to the rescuer, the officers of a public service such as the fire service or police might be obliged to rescue people in danger, 95 to 97. Given the importance of policy in this area of the law, this is post-Michael, pre-Robinson, rules derived from case law ought not to be applied mechanically to new situations, but instead it should be asked whether, as a matter of policy directed to the specific situation under consideration, a new analysis is required, and the result of this would be a law of negligence that was less unified than in the past, but would deal more fairly with individual cases. Paragraph 97. But the reason that's just background, but the reason I'm specifically relying on this is what Lady Patton says at paragraph 50 when dealing with Gibson and all. 628, 629 of the authorities bundle. There is actually, I'll take it from 49. The respondents place significant emphasis on Gibson and Orr, Duff and Burnett. They were two other Scottish cases involving the liability of the fire service. Gibson may be distinguished on several grounds. It was a case in which the police were not acting within the scope of their core duty to prevent and detect crime, but within the scope of their civil function in relation to road traffic operations. That accords with Lord Hope's analysis in Van Colley against Chief Constable of Hertfordshire. Such a point was also noted in Kent and Griffiths by Lord Wolfe, who observed at paragraph 25 that there were a great variety of situations where the police provided assistance to the public because they decided to do so. As Lord Macphail was later to do in Burnett, Lord Hamilton rejected the suggestion that the duties of the police were owed to the public at large, but of course did so in the context of not considering their core duties, but the civil functions which they were carrying out. And then crucially, 50. Further, Gibson may not unreasonably be analysed as a case where their taking control of and then abandoning a known hazard was at least analogous with the situation where the authority created the damage or made the situation worse, having regard to the reference to Knightley and Johns and Rigby. And just, you probably don't need reminding, but if you do need reminding about the facts of Knightley and Rigby. I got one head shake. Just, Knightley is a case where there is a direction by the senior officer to a police motorcyclist to travel the wrong way down a tunnel against the flow of the traffic. But he's forgotten, as I recall the facts, he's forgotten to order that the tunnel be closed. And there's then a collision between either two cars or the bike and a car. And I think the officer is very seriously hurt. That's held to be an assumption of responsibility. But it could also be a creation of a danger case. I mean, again, labels. You can take a set of facts, and in the law of tort, you can pin various different descriptions on them. Rigby is a lunatic has taken possession of a gun shop, is on the roof, I think, with a firearm.
Probably all know that one. Yes.
You don't know that?
No, I think we all probably
you know
all
that.
do
Oh,
know
right,
that
okay.
one. Yes.
And they lobbed the CS gas canister and they told the fire service to go. So that's Rigby, and they were all said to be just exceptions on the edge of the Hill immunity. That's what we got rid of in Robinson. So that's 50. So that's Lady Patton supporting the control point that I made. And then Lord Drummond Young at 62.2. Pure omissions. I mean, the whole report makes extremely interesting reading, but obviously I'm not going to go over everything they say. But pure omissions, I got heavily marked from 60 onwards. But if I could just direct your attention orally to 62.2 at 632 of the bundle. Well, just take it from the top so you get the context. He's talking about Lord Toulson in Michael, that the general rule against pure omissions is not absolute. 4 categories of case exist where the rule has been held not to apply. If there's no duty to act, there can be no liability for the consequences of mere inaction, East Suffolk. If, however, the defendant does act and makes the matter worse than they would have been had they done nothing, there may be liability. This applies both to the exacerbation of the damage caused and the creation of a new danger. And a point that I haven't made but has occurred to me periodically throughout our perambulation up and down this case. Another distinction between our case and, let's say, capital and counties and East Suffolk is at the time of the negligence and the making matters worse, there is no existing damage. There is an existing danger, the ice, but there is no existing damage because it has yet to occur because the fatal accident hasn't happened. So that might just be another point that is worth thinking about. 2, this is the relevant part to control. Where the defender is in control of the wrongdoer, he may be under a duty to control the wrongdoer's actions. This is exemplified by Dorset Yacht. The same may be true where the defender is in control of a situation that presents a danger to others. In such a case, the fact of control carries a responsibility to take reasonable steps to avoid the danger of harm. So that's why I was talking there about a bit of a merger, a bit of flavour of assumption of responsibility creeps in to the analysis under control, about control. An example of this can be found, I think, in Gibson and Orr. In that case, heavy rainfall caused the collapse of a bridge carrying a public road. On being advised of this, police placed warning cones north side of the bridge, but failed to do anything on the south side. Car approaching fell into the river, killing one of the occupants. It was held that liability existed. The police constables who attended the locus had taken charge of the situation, exactly our case, which presented a grave and immediate risk of death or serious injury to road users, exactly our case, who were likely to be affected by the particular hazard. Lord Hamilton remarked excuse me, that the case could be regarded as one where the necessary proximity was brought into existence through an assumption of responsibility. The same approach might well be taken where the police undertake the direction of traffic. Once again, there is an assumption of control of a situation which may present a hazard. The notion of control also underlines the liability of road authorities in Scots law take reasonable care to remove hazards, as exemplified by the numerous cases discussed in MacDonald v Aberdeenshire Council, which I don't think is a pair we have not fully chased up. So that's what I get from A.J. Allen.
Can I just, I'm sorry to interrupt you once more. I don't promise it'll be the last time. Can you formulate the duty of care which you say arises if the police take control of the situation, as in Gibson or as in your submission, the present case?
You mean the scope of the duty?
The duty. What is the duty? How would you define the duty? I mean, it's not just a duty to take care. It's got to be more refined than that.
Yeah.
You want to do that after?
Well, yeah, I'll probably do that at lunchtime, because before I answer that, I'd like to see precisely how I pleaded it. Anybody who's acquainted with my footnotes to legal history will know that rarely do I do a case where I don't have green, purple, I don't know, orange ink. In this case, I don't think there's even an amendment.
Not yet.
Well, exactly. That's exactly my point. So, anyway, I've made the point about not losing this on a if there's another way of sensibly putting it. Right, that takes me then to the relationship between the defendant and the claimant, which I think will be a little quicker. Tipping's formulation, or Tipping J's formulation, was set out by Lord Toulson and Michael, but as noted earlier, paragraph 99, he declined to determine which criteria should apply. As regards what was said in Couch at paragraph 90 in Michael, the key is showing, well, actually I've covered some of this, as an individual or member of an identifiable and sufficiently delineated class was the subject of a distinct and special risk of suffering harm. Plainly we satisfy that for the reasons I've already submitted. The issue was considered in Dorset Yacht, while their lordships' judgments adopted differing approaches, even on Lord Diplock's most restrictive approach, a duty of care was owed to the property owners. The relevant passages as regards claimant-defendant relationship. I slightly lost touch what case I'm talking about here. 102. Yeah, Dorset Yacht. 102 of the bundle, page 170, D1070 D to E. Yeah, at D. To give rise to a duty on the part of the custodian owed to a member of the public to take reasonable care to prevent a Borstal trainee from escaping from his custody before completion of the trainee's sentence, there should be some relationship between the custodian and the person to whom the duty is owed, which exposes that person to a particular risk of damage in consequence of that escape, which is different in its incidence from the general risk of damage from criminal acts of others, which he shares with all members of the public. And again, our analysis fits neatly into that description. And then 1070H to 1071A, I should therefore hold that any duty of the Borstal officer to use reasonable care to prevent a trainee from escaping from his custody was owed only to persons whom he could reasonably foresee had property situate in the vicinity of the place of detention of the detainee, which the detainee was likely to steal or to appropriate and damage in the course of eluding immediate pursuit and recapture. Whether or not any person fell within this category would depend upon the facts of the particular case, including the previous criminal and escaping record of the individual trainee concerned and the nature of the place from which he escaped. So applying that to the present case, the appellant's officers had sufficiently special relationship with the drivers in the locality of the scene on that day whilst it was still in place, i.e. the ice. So then we've got our delineated class of potential claimants. distinct from the public at large. There was a reference, I think, to paragraph 73 of Gorringe by Mr. Warner to submit that there was an insufficiently special relationship in our case, because Lord Hoffman said the counsel in the present case had no relationship with Mrs. Gorringe, but it did not have with every other motorist driving on the stretch of that road in question. Don't need to turn it up, but we say we're plainly distinct from that for the reasons I've already submitted.
So what's special about the relationship? Your Dorset Yacht analogy, you say in the present case the applicant's officers, the appellant's officers, had a sufficiently special relationship with potential users. What more than sheer proximity have you got?
Well, think about Dorset Yacht. They don't actually have at the time, they've relinquished control.
They create the danger in Dorset Yacht. They bring,
that's
they bring
another
all these
way.
lunatic boys onto the island.
Well, that is an alternative way of analysing the case.
Well, it's the way of analysing.
Well, no, I don't think so. Well, I'll check. But it can equally be looked at as a creation of a danger case. But it can also,
Exactly.
it can also be looked on as an assumption of an assumption of responsibility or a control case. Yeah. So they bring them on. I thought they went to the pub, but apparently they went to sleep. And they leave the boys in their tent. The boys there are 8 of them. 4 of them have a history of already escaping. They knew jolly well that these chaps were a risk. So they fall asleep, they have a couple of beers, whatever, and they know the special relationship is between the Home Office, vicariously, and property owners of yachts. So why is that a country mile away from our scenario? Police aware of ice, should have been aware of ice, action taken, relinquishing control. The comparator between the yacht owners are the individuals who are at risk over the next few hours until dawn breaks or the ice melts. So, with the greatest respect, I do not see what the problem is in relying for our delineation of a specific limited class on Dorset Yacht. I mean, that's the submission, be it right or be it wrong. Finally, I think, finally on this vote, Sanderha doesn't assist the appellant in defeating the arguability of the control argument, as that was a case determined by reference to assumption of responsibility in the standard sense, requiring reliance, not the control exception, and query what the courts are going to make of any form of modulation of control by reference to the fact, as we've seen in the Scottish case, the second one, A.J. Allen, some sort of flavour of you assume responsibility because you're controlling. Now, is that different? How is that going to be? There's a lot of controversy about assumption of responsibility, as I've already said, about the concept of reliance. In the child protection cases, whether it has to be the parent who relies or whether you can have passive reliance, vulnerability because of the dependence of the children. You've got vulnerability of poor old Mr. Bird, poor old Mr. Tindall, whose lives ended on this stretch of road at this time on ice when something was absolutely, we say, or they say, or their family say, completely and absolutely avoidable. So Sanderha, assumption case, this isn't in the pure sense. Secondly, the court concluded that the assumption of responsibility exception did not apply as there was no evidence, at the same point, of reliance that on the defendant they gritted the roads. Don't turn it up, but it's paragraphs 44 and 48, 317 and 319 of the bundle. And anyway, and this is a good point on Sandar. I'm not suggest the others were bad. The control exception does not require reliance. It was not necessary for Mr. Tindall to have been aware of the officer's early attendance and involvement. and on the facts plainly that would have been an impossibility. I think I might have forgotten on A.J. Allen to take you. I think on A.J. Allen I should have taken you also to a section, unless I did, a section towards the end. His concluding section. Stop me if I've already done this, but paragraph 91 at 644.
No, you haven't.
Yeah, I'm grateful. Although I've expressed disagreement with part of the reasoning in Burnett, which was, as I recall, a move away from capital and counties in East Suffolk, I should pay tribute to a carefully reasoned opinion which casts considerable light on the problems that arise in this area of the law. A further Scottish case dealing with the liability of the emergency services is Gisborne and Orr, which dealt with the liability of the police for failing to give any warning of a serious hazard on the road. I've already commented on this. That's paragraph 62, which I did take you to, and 84. It appears to me that this is a case where the police took control of a situation in such a way that a duty of care was assumed. In my opinion, that analysis is one that may frequently apply to work performed by the police in controlling traffic or dealing with hazards on the road. It would not, however, normally apply to work performed in the prevention of crime and the distinction of the perpetrators of crime. And that distinction hasn't yet been really debated at a high level. The extent to which there is now a distinction, certainly in terms of civil and operational tasks, whether civil and operational task cases should get some kind of loosening of any of the restraints in terms of the rules of liability said by Mr. Warnock to be based on good traditional principles, and we can't shift them. That's plainly where we're at. And then conclusion 94. If of 95, I won't read this whole thing, but if you see the section that begins about 8 or 9 lines down, in my opinion, a distinction might probably be drawn between injury to the person and damage to property. In part, this reflects the fact that the latter is usually covered by insurance, where the former is not. More important, however, is the fact that the life, health and safety of the individual possesses a greater moral significance than the security and integrity of any property. A normal person will attach greater importance to his safety than his property. The parable of the Good Samaritan would lose nearly all of its force if the man who went down from Jerusalem to Jericho had merely dropped his purse, which the Samaritan saw and returned to him. Consequently, 96, I hope that in an appropriate case, the law might develop in such a way that at least in clear cases where action can be taken without danger to the rescuer, the officers of a public service, such as the fire service or police, are obliged to take action to rescue persons in danger. I realise that this must require a further exception to the general rule that there is no liability for pure omission. I think, however, that policy considerations can be made to prevail over a mechanical of the rule, and then so he goes on about what happens on the continent.
That would not be what we typically describe as an incremental step. That would be simply a reversal of authority that's been going for 100 years.
Well, it wouldn't necessarily be a reversal, but what it shows is there you've got a very learned member of the Court of Appeal in Scotland. That's the reason I show it to you. A bit like the reason that I just turned up Lord Gough, that this is an area of acute debate, both academically, in professional terms, and at some stage possibly politically. I won't get into politics, but I've already made the point about the constant tsunami of complaints about failures of the state. Nowhere in the public domain is there really a true understanding of what is said to be, let me say, the restrictive reality of the ability of the families of people who have not been protected, etc., to actually get recourse. And again, remembering the jury, but I can't resist saying this. When, from personal professional experience, when cases come up that are so horrendous, but still come against these strict principles, the state settle them. the nasty ones go. And that, well, there may be some humour, but it's the truth. It's the truth. And that's why this type of case, which is funded on a CFA and is, is just a modest, ordinary traffic accident, well, you know why I say that, has come before the court. So these are the opportunities to clarify the position and not strike them out. Right, I'll say no more. That's 1 o'clock. I can start on the hypotheticals. So I've got 4 hypotheticals to deal with. And then I've done ground 3, thank goodness. And then a short concluding section. So I would have thought, depending upon questions, probably about 15 minutes. And then I can do it now if you want, or wouldn't mind doing it now in a way.
Completely irrelevant. I understand that your colleague in Paris would be Duncan Fairgrieve.
Yes. He's written all the
Well, I
books.
normally refer to him either as doctor or professor. At some stage, we're going to put him on the list on the front of a judgment. Could we have the preferred denomination?
I could do that. I think he doesn't like being referred to as Professor Fairgrieve, although he is a professor in a French university. I think it's Dr. Fairgrieve.
Can he live with doctor? You referred to him as Mr.
I think he's a mere doctor, and he will come into the thinking in the hypotheticals. There's a bit of Fairgrieve in the hypotheticals, which does involve a couple of doctors as well. So I'm in your. So
We're going to rise now.
I'm very grateful. Thank you very much. That's the right decision.
Yeah. Good. 2 o'clock.
Thank you.
Goodbye.